Was to endeavor to offer you any sort of, definition. Don't take this, verbatim, but what I came up with is this: a succession of templated questions which sets the framework for the prosecution's witness. And most certainly when it comes to an officer witness, and being that our officer is the only witness we have for the prosecution, we'll always start with that same almost templated succession of 13 questions. But as I've already, of course, alluded to at the beginning of the presentation, why are we asking these? What is each question actually reflective or representative of? Why are we doing this? And that is exactly what we're going to talk about. So, question number one: officer, by whom are you employed and in what capacity? So this, is very obvious. If the witness is a uniformed police officer that says police across their chest, maybe even the JP asks, why are you even asking this? But as we've already touched upon, needless to say, there's numerous enforcement agencies, federal, provincial, municipal. There's numerous titles. For example, our officer, our witness here, Special Constable Joe Law. There's conservations officers, etc. And, obviously there's going to be varying legal authorities that an officer, or investigating officer for that matter, may have, dependent on their tenure. But ultimately, at the end of the day, why are we asking this question? What are we trying to endeavor to portray and solidify? It is this: is this a provincial offenses officer that we actually have on the stand here, i.e., did they have an actual legal ability and authority to commence a proceeding under the POA? So that way, which leads us to question number two: how long have you been in this role? Seems like a formality. So what are we really trying to ask with this question? Well, was the officer even in his or her current role at the time of commencing the proceeding? Maybe the officer was doing something else at that time. Would be representative of some of the questions we may need to ask. Maybe this is something we need to be cognizant of. Was the officer even employed with his or her current agency at the time of commencing the proceeding? Maybe the officer now is a conservation officer with the ministry, with some ministry in Ontario here, and for that matter, this is a charge that maybe the officer laid when his or her worked for a different ministry or Go Transit, or who knows what the case is, right? Officers should ideally be able to provide an actual start date of their current tenure. So arguably, the officer worked and strived so hard to be in their current role, and it should be a commemorative, celebratory day to find yourself in your new dream career. And even if it's not, well, guess what? We always preach to the officers: know your start date, because it's best to get on the stand. How long have you been in this role? I've been so employed in this role since December 13th, 2018, or whatever the case is. So that's sort of a biggie there. And I put a couple asterisks on the bottom of the screen here because, and this most certainly, as some of you know, is an item that could take us into a whole other territory, if you will. Length of employment, which can equate to, of course, the amount of experience that the officer has, can most certainly lend to being qualified plausibly as an expert witness. So this is most certainly something that would be relevant. Should we find the need to go down this type of role? And very quickly, this is taken out of a court here, R.V. Bowman. So this quite simply states that you can be an expert without any formal education or a degree, so i.e. your amount of experience. So I'll just read this very quickly verbatim. So in that case, the defendant was charged with dangerous driving causing death and impaired driving causing death. A police officer who had performed several accident reconstructions was qualified as an expert on the causes of an accident. So the defense objected on the basis that it was not a quote-unquote qualified engineer. And of course, as we know, that need not be the case. The Court of Appeal rejected this argument and noted that a witness can obtain the necessary expertise through experience and training. So yes, knowing the length of time someone's been in their current role or the relevant role to the matter before the court, this most certainly may weigh in favor of the prosecutor should we need to endeavor down the road of qualifying this person as an expert for whatever the matter might be. Number three, did you investigate the matter before the court? Now, this seems like a bit of a no-brainer. However, I can tell you where at least I have observed to get some prosecutors into a bit of trouble. So, obviously, this is going to determine the purpose of the officer's testimony. But what I mean by that specifically is this. The answer to this question is going to determine the actual role that the officer played. Not every officer involved in a role is the investigating officer. The officer could have very well acted solely as a process server. And needless to say, The answer to this question is going to go to credibility. So the officer should not answer with a simple yes as a matter of a formality if the officer didn't investigate it. So, as for example, the earlier matter I used with when we talk about the order of calling witnesses, the go transit matter, the last officer involved simply only did a door knock and served a summons. So most certainly, if this officer is on the stand as part of this trial, did you investigate the matter of the court? No, I simply only acted in a process server, or what I would respectively describe as a process server role in such and such state. I did, serve the summons before the court to the defendant or something to that effect, but at least alluding, of course, to the JP, what he or she should be listening to as far as the role you played, but of course not, misleading or sort of, part of my language, screwing everything up because you were not the investigating officer and did nothing of the sort. So it's, although it seems like a bit of a formality, obviously this is to determine the purpose of the officer's testimony. Were you in uniform at the time? Now, this most certainly is going to set the context for the matter. More specifically, was the officer perceived to be a person in authority? And this is very important when it comes down to a number of different considerations in the course of the officer's investigation and maybe even getting admissions of guilt and charging the officer. Because as you can see on the third point here, it sets the framework for evidentiary considerations, more specifically admissions of guilt, because a voir dire will be required if the officer was in uniform and perceived to be a person in authority, if what we're dealing with here had anything to do with a charge being laid in correlation with an admission. And as I advance the slide, this has to do with the test for admissibility, for voluntariness. When it comes down to admissions, this is a matter of R.V. Oikel. So if the admission is made to a person in authority, the Crown must prove beyond a reasonable doubt that the statement was made voluntarily. So this is taken out of the precedent case, which I talk about in my hearsay seminar for any of you who attended that, the matter of R.V. Oikel. So very simply, it's a 4-caveat test. There cannot be any threats or promises, no oppression. The defendant had an operating mind, that was no police trickery. So again, if an admission was made to a person in uniform, that person is perceived to be an authority, and we have to make sure none of these 4 caveats are there. But that being said, if the officer was not perceived to be a person in authority, i.e. plainclothes, the defendant had no idea this person was a quote-unquote agent of the state, we don't have to go down the realm of the voir dire. That statement we presume to be, of course, admissible without a voir dire, or voluntary, so to speak. Now, number 5, did you make any notes in regards to the matter? Now, this, of course, is where we start to set up the framework for the qualifying officers, for qualifying the officer's memo book notes. Now, obviously, the memo book notes are considered to be the fruits of the investigation. Every officer, for argument's sake, should at bare minimum be carrying a memo book, making notes at the time of the offense, shortly thereafter. Obviously, this is speaks volumes as far as what's going to be disclosed at bare minimum to the defendant, with that defendant having the right to make that full answer in defense. Now, where were the notes recorded? I.e., if there was a memo book, of course, they're going to say memo book, and this most certainly is going to establish that the officer utilized that standard, officer's memorandum notebook, or for that matter, as we're, starting to see more as, technology advances and everyone's coming to grips with the 21st century, as indicated by the asterisks there, we're going to find out if we have to go down the realm of whether the notes were recorded electronically, so i.e. inputted and uploaded to some type of internal server, things of this nature. And again, not to go down the realm of Highway Traffic Act, but as for example, officers maybe on a traffic stop who are part of a traffic unit, they're basically inputting their notes directly into, their computer. As for example, and when it comes down to trial, they would maybe print these notes out, as for such example, but that's sort of the avenue we start to go down. Now, with that being said, just as a quick caveat here, and I won't go too far into this, but when it comes to the idea of those digital notes, this is most certainly representative under the Evidence Act, Revised Statute of Ontario, which would be what we look to for rules of evidence in the provincial offences hearings. Most certainly, when it comes down to what we can consider electronic records or notes that are being kept electronically, this is all spoken about in 34.1 when it talks about data, electronic record system. So the latter of the 3 there, of course, most certainly alluding to those electronic notes and the computer systems or servers, if you will, that these electronic notes are going to be housed in. Now, as far as the admissibility or authentication, as it's worded as here, Well, the person seeking to introduce an electronic record has the burden of proving its authenticity by evidence capable of supporting a finding that the electronic record is what the person claims it to be. So most certainly the officer, if wants to rely upon their electronic notes, they have the burden to prove that, well, these are actually electronic notes they made at the time, and everything speaking to the authenticity, obviously, of these respective notes. Now, the act does go a little bit further, talking about how the officer can endeavor to do that, as well as a presumption of integrity. So in lack of any evidence to the contrary, and as long as the officer being able to speak to, of course, what these notes are, where they came from, how it would be the case that no one would get into the server and screw with them, pardon my language, things of this nature. This is what these respective sections of the Evidence Act talks about. But again, this all under Section 34.1 of the Evidence Act. I'll leave it at that. This is something you can, view perhaps a little bit more in depth after the webinar on a later time. So number 7, when were the notes made? So obviously the typical answer is going to be at the time of the offense and shortly thereafter. That's the usual answer we get. But that being said, it may be the case for the officer, depending how busy this enforcement agency is. Due to the call volume, it may have resulted in notes being created well after the incident, which is, it can happen, and that's okay if necessity dictates. I mean, we of course, as enforcement entities, so to speak, or in the enforcement world, if you're busy, you're busy, and that goes without saying. However, in asking this question, it is going to address and account for holes in time that we want to be able to speak to before the defense has a chance to, because as most of us well know, this is going to be a great area of vulnerability to be attacked by the defense. There are holes in times. This suggestion that, you made these notes much later because Lord only knows who you talked to in the interim or in the, between the time the offense happened and, much later when you made these notes, maybe they coached you. It's that whole sort of song and dance that the defense is going to plausibly take the officer down. Do the notes appear in your own handwriting? So this, of course, is going to establish, goes without saying, that the officer authored his or her own notes. But for that matter, it's going to establish whether another person may have written in the respective memo book entry. And it's not uncommon, should an officer want to take a witness statement at the time, at the scene of an incident, to basically hand their notebook over and a pen to this witness and say, write down exactly what happened. They sign, the officer signs underneath. So, of course, this is something you want to speak to. So the defense doesn't say, such and such page at such and such time, your handwriting changes and who was writing in your book. And, obviously, again, this is something you want to speak to and just, set the framework for these notes to make sure everything is kosher, if I can use that word, with the fact that there's, someone else writing in the book. Have there been any additions, alterations, or deletions? Well, this, of course, goes without saying, going to address credibility, i.e. the notion of fabrication of evidence, most certainly showing that this has not been the case. It's going to address any or abnormalities in the memo book notes. And of course, it's going to allow for explanation before the defense can raise any issues. So, even if it's simple as maybe 2 letters of a word crossed out and initialed, the officer will say, it was a spelling mistake, or I was writing the wrong word, or whatever the reasonable, rational explanation is going to be. It allows to address that and make sure the officer's cognizant of it before the defense, again, tries to do that whole loophole and raise any credibility issues, for lack of a better description. Do you have your memo book notes with you today? And if so, do you require them? So this is going to establish, of course, that the officer has brought the same respective memo book from the time of the actual incident. So it's the same book that you wrote in at the time of defense shortly thereafter. It's not another book that maybe you fabricated later. And definitively, the defense is always going to compare their disclosure copy of the memo book notes with your actual memo book notes. So make sure you don't play any, to the enforcement personnel, make sure you don't play any funny business there. But of course, it's going to establish the officer would like to utilize the memo book notes for the trial. And obviously, it's going to be only for the purposes of refreshing their memories for the particulars, which we'll get into. I don't want to jump the gun, but as well, and as I've already alluded to at the bottom, defense will compare disclosure to the actual memo book notes. So that's why we're sort of addressing this area here. And ultimately, again, as I've already alluded to, why do you require your memo book notes today? Again, the typical answer is to refresh my memory to the particulars, such as dates and times. But really what we're endeavoring to establish here is the difference between a present memory refresh, so i.e. the officer has some kind of recollection about this, but is refreshing their memory about it, versus a past recollection recorded. So in other words, I don't remember anything about this, but everything I've recorded must have been what happened. I did it at the time. So, it may be the case we're going to have to utilize these notes as an exhibit to be relied upon in the absence of the officer speaking perhaps to what, the essential or rather relevant material evidence is, but maybe setting the framework or speaking to some of the inferences of it, if I can word it that way. That'll make a little bit more sense when I move forward on the slide here. Now, do you have an independent recollection of the matter before the courts? So this little phrase taken out of the matter of RBKG, or what it's more commonly referred to as KBG or KGB statements for that matter. I go over this a little bit more in my hearsay presentation, but I'll just read this quote a little bit from this precedent case here. So it says, there is a danger in allowing the phrase refreshing memory to apply to those cases where the witness has no present memory, but is able to state that she accurately recorded a past event. In such cases, the witness has no present memory. The evidence, to the extent there is the past record. So again, as I've already alluded to on the past slide, most certainly the officer can test to the idea that, the notes were accurately recorded. So the inferences speaking to that. But as far as what the notes actually state, in the absence of the officer having a present memory refreshed, we're going to be relying on the notes as the past recollection recorded. And that's why I cannot stress enough, and always do in the enforcement world, and to all the enforcement people watching, I cannot stress the importance of having complete, diligent, meticulous notes that speak to all the relevant material items that we need to be there, so as the prosecution to have even a hope in heck of having the plausibility of a reasonable prospect of conviction. And this, of course, speaking still a matter of R.V. Bucharest, speaking still to sort of the, threshold, if I can word it that way, or the four conditions that need to be met as far as the ability to rely on those memo notes as the past recollection recorded, if that's the rule we're going down. So I'll read this very quickly verbatim. So where a witness has no memory of the events, as we've already stated, the notes themselves constitute a record of a past recollection and become admissible evidence themselves as an exception to the hearsay rule if four conditions are met. So these conditions are summarized as follows very quickly. A reliable record. So the past recollection must have been recorded in a reliable way. I'll leave it at that. Timeliness, the record must have been made or reviewed within a reasonable time. So, i.e., hopefully the officer could say at the time of the offense, shortly thereafter. Obviously, there has to be an absence of memory at the time the witness testifies. The witness, the officer, cannot have any memory of the recorded events. Obviously, we wouldn't even be talking about this if that was the case. And a present voucher as to accuracy. So the witness, although having no memory of the recorded events, must vouch for the accuracy of the assertions in the record. So we've already talked about the idea that the officer most certainly can speak to the accuracy, in regards to how these notes were made and all the inferences thereof. So I'll sort of leave it at that for now. And ultimately, the last question number 13. Leave it the court, your worship, for the officer to refer to his or her notes. Of course, we're asking for permission for the officer to refer to his or her memo book notes if we're going to be, moving forward with the officer using these notes to refresh his or her memory to the particulars. Now, obviously, the defense can object, as I'm sure all of you know very well, and or ask questions in relation to the memo books, and, may very well be the case depending on how involved of a matter it is. But nevertheless, this is where things sort of leave off as far as the succession of questions.